Hey guys, well, at the end of my last live, that was just a few hours ago, I said, I'm going to caveat, I'll see you tomorrow with, I'll be back later if anything new develops. If anything new develops, and oh my word, it has developed. Dear me, you can't even turn away for like one evening without there being another round of documents. And yeah, so it took me a minute to get my head around who was actually filing this, because it's like the people who filed it are names I've never heard before, but I think I've got my head around it. So we're going to go through these documents. All right, so let's give people a chance to hop on before we start, because this was very short notice. I thought, do I go on tonight or do I leave it till tomorrow? And then I thought, if I don't do this tonight, because it's like 10:15 for me here in the UK, and I thought, if I don't go on tonight, I'll wake up in the middle of the night and then I'll be compelled to go on, and then it just gets ridiculous. So that's why I'm here. But hello, Rambling Rome, Dulcie, Owen Flo, Sassafras Kath, Samantha, Marissa, Carolingon, Pamela, Cat Lover. It's gone way off the rails. I know, isn't it? Isn't it though? Blambriel, that Newfie girl. Yes, you caught alive. You did. Esme, Sandra, Mel, that Newfie girl. I've said you. Petunia, Stephen. What else is there? Sharon, Kristin. Trying to pick out the names that I haven't said. DC Primetime. This old nurse. Tammy, Juju, Brenda. Purple AJ, D, Grey Wolf, Paranormal. Yay, I got to the end. So we've not got a great deal of people in, but this is very important because this takes a small part, or it could be potentially a very large part, of the Delphi case to the Supreme Court of Indiana. Why is this so important? Because there will be people with eyes on this case who are not connected to, well, hopefully not anyway, hopefully not connected to the good old boys of Delphi. And if you want a deeper discussion into the good old boys of Delphi, then go and check out the live that I did a few hours ago. So it'll be the live previous to this. And I did have to remove 7 minutes of that live. YouTube contacted me and said there was a copyright claim. So it's not a copyright strike, it's a copyright claim. And it doesn't give a strike on your channel or anything like that, but it means that whoever claims that live gets the money from it. And when it's only a small portion of a 2.5-hour live, guys, I don't want some music company to get all the money from my live. That's not how this works. So it's some of the music that R&M Productions used, and a music company claimed it. So I had to remove 7 minutes. It doesn't affect the overall stuff. It's just 7 minutes of one of R&M Productions pieces, and it's right at the end, so it doesn't have any, right at the end of that piece, so it doesn't have any content issue really. But R&M Productions, the link, if you want to go and watch everything from their channel, because I played, how many videos from them did I play? 3 this afternoon, so please do go over and check them out. All right, so these documents, what are we to make of them? What are we to make of them? Well, I try to be on top of the case, but I just feel that I'm drowning in it. Because every single day there's something else and there's something new. But drowning in it in a good way, I will say. Because the Supreme Court of Indiana will have eyes on what Judge Francis Gull has been up to. So although these court documents seem very dry, this is very, very important. This could be a turning point for this case. Or it might not. We'll have to wait and see. However, it's in my opinion, it's positive. So there's two documents, one that's 12 pages and one that's 22 pages. So they're both relating to the same thing. The 22-page one is all the supporting evidence for the 12-page one, if that makes sense. So we don't have to read a 12-page and a 22-page word for word, because some of it overlaps and some of it's just kind of the legal procedure and stuff like that. So I'll spare you that. But if you want to read the documents, I'll tell you where there's a good place to get documents, court documents, where you don't have to go scouting about on, you know, the clerk of court and try to work out where these things are, because I can't work it out for Indiana. I don't know whether it's because I'm in the UK. I don't know. But there's this Reddit thread here called Delphi Docs, and the good people of this thread, is that what they're called on Reddit, seem to just get everything and post everything. So yeah, the documents are like there. People just post them on. So the game is on. The game is on. And the links here in this one. So someone called Yellow Jacket has put them on. So that's where I got them from. But they are genuine court documents. So don't worry about it being Reddit. But just to let you know. Just to let you know. All right. So the first document here, this is the verified petition for writ of mandamus and prohibition. So, you know, legal eagles like to use real words. But basically, this is a plea, I guess, to the Supreme Court of Indiana to take a look at what Francis Gull is doing. I think that's what we can say in a nutshell. But what confused me initially was that Richard Allen was called a realtor, a state of Indiana, on the relation of Richard Allen. So rather than it being Richard Allen being the defendant, he's classed as a realtor. So this is a writ or a plea to the Supreme Court to the Supreme Court to just take a look. And it's three people who are not connected directly to Richard Allen's defense or his previous defense. So I guess you would say, and I made a TikTok, and I wish I kind of made it clearer on that TikTok, but you get like 60 seconds. But I said this is from Richard Allen's defense team, but the team seems to be getting quite large or something, I said, because there seems to be a lot of legal people who are really up in arms about this. You know, people who practice law in Indiana are really getting behind Richard Allen and what's going on in his case. And I genuinely have never seen anything like this. That people who are not attorneys for Richard Allen, they've got no direct connection to the case are stepping out. They're stepping out to stand up for the law and the Constitution and for justice. And that to me is really heartwarming. And these three, so you go back down to the bottom, and these are these people here. So by Maggie L. Smith, Cara S. Weinecke, I don't know, and Jesse A. Cook. So one's from Indianapolis, Indiana, one's from Brooklyn, Indiana, and one's from another one from Indianapolis. So these are attorneys in Indiana who've put their names to this document to support Richard Allen, or at least what's going on, the travesty of justice that's going on in this case. So as I said, I'm not going to read these word for word, but I'm going to read quite large chunks of it. So I know some people find it really dry to listen to court documents, but I promise you, before you tune out, I promise you that this is incredibly important. Incredibly important. Not just for Richard Allen, not just for the Delphi case, not just for the good people of Indiana, but potentially for anybody who finds themselves as a defendant in a criminal case who expects that justice is fair, that the justice process, that the scales of justice are equally balanced. That, okay, if a legal investigation and a prosecutor takes this case and there's probable cause for an arrest and somebody's detained, okay, well, yeah, that's part of the justice process. That's how things have to play out. But at that moment, that person is innocent till proven guilty in a court of law, and they get their day in court, right? So for you guys in the US, the Sixth Amendment covers this. In my country, you have to go all the way back to 1215 AD to the Magna Carta, the Great Charter. That's where our basis in law comes from. King John was riding roughshod over England, and his barons rose up against him, and they got him to sign the Great Charter, the Magna Carta. And he signed it because they basically ambushed him in a field and made him sign it. And then when they left, he ripped it up. But unfortunately for King John, and fortunately for the good people of England in 1215, King John died a year later under weird circumstances. But the Magna Carta stuck. So we get our foundation in law from the Magna Carta. And you are tried, you should be tried by a jury of your peers, and it's unfair to imprison anyone unless there is a justice process, or else it's false imprisonment. All right. All that said, the court has expressly declared that there are strong societal reasons for allowing public access to court records, and denial of that public access could compromise the judiciary's role in society, inhibit accountability, endanger public safety. Okay. think we can all agree that there needs to be transparency in the justice process, not just for the good people of Indiana, not just for the good people of the United States, but for justice everywhere. There has to be transparency, as much as there can be. Obviously, there are good reasons not to put out there all the evidence. All right, that's problematic. But for the actual process, what we're talking about here is the process and the procedure of law. That has to be transparent. That, yes, the judge is, I guess, the law in the court, in any trial, but the judge, him or herself, also has laws that they have to abide by, that have been set for every judge. So they cannot, no judge in any civilized country can start making up their own rules, right? So this is what these three attorneys are declaring. The court in Indiana, so the Supreme Court, this court, the Supreme Court of Indiana, that's who they're addressing, has said that there should be transparency, that the public should have access to court records. We should be able to see the procedure, what is being talked about in court. All right, so we move on. This is one of the most high-profile cases this state has ever seen, and for many Hoosiers, this case marks the first time they have followed the workings of an Indiana court, because it's so big. I mean, everybody loves Abby and Libby. Everybody wants to see justice for Abby and Libby. And as I keep saying ad nauseum, anything other than a fair trial for anybody accused of their murder, it is not justice if there is not a fair process. Whether Richard Allen's guilty or not, there has to be a fairness and a balance. You know, everyone knows the scales of justice, and the scales of justice on either side are equal. And if somebody brings a prosecution against you, you've got to be assured that there is an equal right for that person, that accused, to have a defense. And that judge who sits, you know, as the law of that court, they have to balance the scales of justice. And in this case, Judge Francis C. Gull is not balancing the scales of justice. She's not balanced. And therefore, anything moving forward creates a massive problem for justice for Abigail Williams and Liberty German and their families who've waited. It's going to be 7 years by the time this even has a hope of getting to trial. The trial was set, jury selection was due to start on the 8th of January, which is just a month shy of a 7-year wait for those families. And now we have this. So I'm so pleased that now the Supreme Court of Indiana will have to have eyes on Francis Gull. They have to. Okay. Yet, virtually every turn, the access to public record rules, and most recently, the Indiana trial rules, have been violated. And Hoosiers and the media, both local and national and international, right? The international media is looking at this, right? You know, you look at things like Mail Online and publications like that, The Sun, they're British, right? They're all talking about this. We know Abby and Libby in the UK, right? Okay. I've been left on the outside looking in. Instead of the sunshine that public access is supposed to provide, the public and the media have been left in the dark. Okay, so they're addressing the Supreme Court because the trial court has a clear and absolute duty to follow this court's mandates, ensuring public access to court records, but it has failed to perform that duty repeatedly. Repeatedly. So it talks about and I'm not going to read all of this page, but I'll summarize it. In December 2022, the entire case appeared to be sealed. You couldn't get anything, right? The PCA came out, but nothing else. Nothing else came out. And then on June 20, they say June 28th, but the document file is June 27th. And I'll show you what they're referring to, because I got the Google Drive. So this is all in a Google Drive. And these are the documents. 118 documents were released on June 27th. It's impossible to know what these are relating to, right? A lot of these are just files with no identifier in the title. And you can't work out based on the date of the filing here, because they're all the same date. This is the date they were released to the public, not the date that the document was created. So if you want to go through and have a look at these documents, it's impossible to read them in a chronological order or in any order of your choosing, because for the majority of these documents, you can't even tell what they are. So that's just one example of how problematic this this transparency is. Just looking at that one thing in itself is problematic. But you might think, well, okay, fair enough. It's difficult to read those documents, you know, that were produced between Richard Allen's arrest and June 27th. But it's a much, much bigger problem than that, because, well, we're going to carry on. June 28th, 2023, the trial court explained that all of those documents have been excluded from public access to comply with the court order dated December 2nd, 2022, which prohibits public comment, commonly referred to as the gag order. Now, I'm glad that this is now in a legal document, because I've been telling people until I'm blue in the face that the gag order does not relate to court documents. The gag order that was issued on December 2nd is about the extrajudicial comments. So that means the things that attorneys might say, or law enforcement might say, or anybody connected to the case might say to the media and to the public outside of the court. What is said in court, or what is said in the documents that are relating to that court, is not part of the gag order, right? So saying that, we had to seal all of this because of the gag order, is Judge Francis Gull. That's the first indication that she did not want transparency because she's hidden behind a gag order. That's what she's done. She's hidden behind a gag order. And she's brought that back now, or at least people who are defending Francis Gull have brought that back by saying that Andrew Baldwin and Brad Rosie should not have made public the 136-page memorandum. No. They did not breach the gag order. They did not. That was a court filing. That was a court filing. And the case on the 27th of June, all the documents relating to this case were unsealed, or at least most of them were, because this is where we get into things that, well, I didn't know. So if we just skip down a little bit. Okay. All right. Where shall I read from? Okay, I'll read from here, point 7. Because the CCS in this case still has every one of the 118 court records excluded from public access, which is why I can't find them. But I've got them all in a Google file. That the Google Drive, and I think there's a Dropbox or something that were released. They were all released, right? But unless you know where that is, or you managed to grab it when the media were talking about it, then you've got nowhere to know where those documents are. Okay. And then the more recent ones are also incredibly difficult to get hold of. That's why I'm using this thread on Reddit, because they're getting them somehow. Okay. It's just really difficult. It should not be this difficult to keep up to date with what's going on in this case. I mean, look how organised Idaho are. Right? They've got, even Brian Koberger's even got his own section. He's even got his own section. Chad Daybell's got his own section. Idaho are very transparent. You know, yeah, some documents are sealed, at least temporarily. And of course, there's always things like names and stuff redacted. That's fine. That's fine. And there's very few documents sealed in Idaho. It's stuff to do with search warrants. It's stuff that's got an evidentiary value. All right. And there's very few, and actually they get unsealed like I don't know, whenever they feel like it, they get unsealed. All right. Okay. Well, where was I reading? Right. Okay. More recently, the trial court has begun removing and excluding filed documents from the system altogether. So we know exactly what they're referring to. And by trial court, what they're actually meaning is the judge. The judge is ordering the clerk of court to remove documents. As we've seen, if you've been following my coverage of this over the last few days, you'll know that the judge is just removing stuff that the defence are filing, or should I say, Richard Allen's ex-defence are filing. Ex for now, at least. For example, on September 18th, 2023, Allen made what is known as the Franks filing, wherein a defendant seeks to present evidence that the officer who prepared the probable cause affidavit, Tony Liggett, misled the court to believe probable cause ever existed. So we've all been talking about this for the last month now, right? Alan filed 3 documents with this Frank's filing: a motion, a memorandum in support, and an exhibits list, and made them all publicly accessible because the case is public. But somehow, I love the way they're wording this, but somehow within the court has since removed or excluded the Frank's memorandum from the court system altogether. So fortunately, right, the good people of social media were able to grab it and it circulated within the 2 hours that it took Francis Gull to hide it from public view. Likewise, after the trial court attempted to force Alan's counsel, attorneys Andrew Baldwin and Brad Rosie, to withdraw under duress, and in direct conflict with Alan's express declaration that he wanted only attorneys Baldwin and Rosie to represent him, and the letter that Richard Allen signed is on my community wall. I put that on earlier on. Alan instructed his counsel to make certain filings on his behalf. On October 27th, just a few days ago, however, the trial court ordered the clerk to remove all of Alan's filings from both the county court system and the electronic case file. So they go on. I'm not going to read all the kind of legal points here, but they go on to state that this nonsense is in breach of Indiana law. And they provide all their evidence for why they believe that they've got to write to the Supreme Court with this problem. So it's all there. If you want to go and read it all, those are all the legal references or the precedents that have been set that they're basing this opinion on. All right, so all of that's there. All right. Now, this document is the is all the supporting evidence above and beyond the legal stuff. Right, the legal, this case provided this precedent, and this is why we do it this way, and this case does this, and blah, 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 right? All the legal jargon, right? This is the evidence. This is the stuff that a lot of us know if we've been following this case really closely. But now, the Supreme Court of Indiana. I'm always getting those confused. Indiana and Idaho. And every time I mention the Idaho case or Brian Koberger, I then start saying Idaho instead of Indiana. But anyway, this is Richard Allen's brief in support of petition for writ of mandamus and prohibition by Maggie L. Smith, Cora S. Wernicke, and Jesse A. Cook. Again, for the people who weren't here at the beginning, these are not attorneys for Richard Allen, which is what confused me initially with this. But it seems that Richard Allen and his cause have got support way beyond Andrew Baldwin and Brad Rosie, who are hanging in on they're hanging in for him. These are people who are practicing attorneys in Indiana and who are following this case and realize what a travesty Francis Gull is making of this case. So let's read this. So this is all the evidence that they've got beyond the legal stuff, right? This is the evidence actually about the case. So, hundreds of documents are improperly excluded from public access. This case involves one of the most high-profile matters in Indiana history. On April 5th, 2023, defendant, realtor Richard Allen, filed an emergency motion to modify safekeeping order, exhibits, and a proposed order marking everything as public documents. Okay, weird. So this is the emergency motion to modify safekeeping order. So this is what it looks like on the Clark system. Okay. Thereafter, someone within the court system changed all of Allen's filings to confidential and excluded all of them from public access without any notice to or from Allen. From that point through to the end of June, more than 125 separate court records were excluded from public access. I'm sure that this goes back to December, not to April. I'm sure that the whole case was sealed. I'm sure of it, because none of us had seen any of the documents. None of us had. Until this document dump to Google Drive and there's a Dropbox that has all the same documents in on June 27th. Because we were all complaining, the media were complaining. It wasn't that something just happened in April. This was a problem since day one. But what we got in June was 118 documents. So there's 7 documents that we still don't know what they are and we haven't seen. So you don't know what you don't know. Anyway. But not a single one of these excluded documents includes the mandatory access to court records, ACR form, identifying the specific Rule 5 grounds upon which exclusion is based. As of today, there is no way for the public to know the grounds on which any document was excluded. So, you know, because most of the documents, the 118 documents, are innocuous. Right, there's nothing in there that I can see that's problematic. There's nothing evidentiary about them. The things about court procedure, like their motions, there's some search warrant stuff in there. Right, it's dry stuff that's just the procedure and the process of the pre-trial court. So why did they all have to be sealed? Why were they all excluded from public record? It's insane. So it raises a red flag. Now, obviously, at the time, it wasn't a big deal. You know, it's, oh, great, we've got all these documents now. And then you look at them and you think, well, there's nothing really juicy here, right? It's just court stuff. Nothing really juicy. It's one side talking to the other side. But it's a problem since September, because we've then started to realise just what a controlling and disregarding of law Judge Francis Gull actually is. It's all come to a head because of what's happened since September. So on June 8th, a member of the media requested access to these excluded court records. On June 28th, the trial court ruled on that motion and explained that all of the documents had been excluded from public access to comply with the court order. Again, the gag order only governs extrajudicial comments. Okay, the trial court then allowed the parties to agree to exclude the entirety of certain records from public access, even though both actions are prohibited. Blah, blah, blah. Okay, first, a court cannot exclude records otherwise accessible to the public because the parties agree to do so or because the parties have entered into a trial rule. Okay, so again, this is just legal stuff. Second, unless everything in the document can be properly excluded from public access, the document cannot be excluded in its entirety. Rather, there must be a public access version and a non-public access version. And the public access version has the confidential information redacted, but all the non-confidential information in that document is still publicly available. So that's normal. That's normal. So a PCA will have witness names redacted, for example. Search warrant information might have, you know, if they've issued a search warrant for somebody who it turns out isn't connected with the case, like, you know, let's say in the Idaho case, there's some search warrant for phones and things that are, you can guess who they are from the surviving housemates and probably the partners or boyfriends, girlfriends, etc. of the victims. They still issued search warrants for their phones, right? Because in those early days, they didn't know who was connected to who, and they did that, but they redact those names, right? That's normal. But sealing records just in their entirety, when they don't have evidentiary value, they're just part of the court process, is insane. With regard to the other documents that have been improperly excluded from public access, the trial court did not order the clerk to make the documents on the Carroll County system. I don't know what CCS actually stands for. Clerk of Court system, maybe. Something that clerks do all the time, which would have allowed the public to identify the filings they wanted and then access those particular filings. Okay. Instead, the trial court created a link, Allen Superior Court, US. Let's have a look at that. Oh, look at that. Oh, there we go. The same file is also available on Google Drive. Yeah, so these are those documents that were all released in June. But good luck finding them. Good luck finding them if you don't know where they are. Oh, I've lost my place now. Great. Okay, so we can skip a bit here. We've already talked about this. That's what that looks like. I've shown you the Google Drive, and it's impossible. It's impossible to find anything. All right, but that's not it's inconvenient. It's inconvenient. The big issue started in September, as we know. More recently, on September 25th, the state filed a motion to exclude all future filings. Now, I didn't know this. I did not know this. Right? Did you know this? On September 25th, the state filed a motion to exclude all future filings from public access. Did you know that? I didn't. Until the court conducts an in-camera review of each filing. So an in-camera review is nothing to do with cameras. It basically means that the judge looks at it. The judge looks at it and decides whether that document should be given public access or not. And the state then excluded that motion from public access. So if you did not know that the state filed a motion to exclude all future filings on September 25th, if you did not know that, it's because they didn't want you to know that, because the state then chose to seal, to hide that from the public. That's a problem. The trial court has neither ruled on this motion nor set the matter for a Rule 6 hearing. So they just did it. They just did it. They filed the motion that they want the judge to look at everything. And of course, because the judge is biased towards the state, they've probably already agreed with her that, oh, well, you know, anything that the defense files, will just hide it. I'm just guessing, but that's the way things seem to be going. All right. Alan files a Frank's memorandum of law, and the trial court removes it from the public without notice or hearing. On September 18th, Alan made what is known as a Frank's filing. So we read this in the previous document. Alan filed 3 documents, and that's what it looks like on the system. Okay. We've read the 136-page memorandum. There's also an exhibit file. Okay. In summary, above shows that the memorandum was filed as a public document, but someone within the court removed or excluded the 136-page Frank's memorandum from the system altogether, again with no notice to Alan. The trial court attempts to effectuate the removal of Alan's chosen counsel over his objection and without his consent or approval. So remember, this is all now in the hands of the Supreme Court. In early October, counsel for Alan learnt that Mitchell Westerman had surreptitiously and without authorization photographed crime scene evidence, in this case, that was being stored in Andrew Baldwin's office, and then disseminated those photographs without Attorney Baldwin or Alan's other attorney, Brad Rosie's, consent. Attorney Rosie and Baldwin immediately informed Alan of this theft, and Alan, I can't say that word. I can't say that word. But basically, Richard Allen wrote to the court that he still wanted those attorneys to represent him. And that's the letter. I want you to notice the date, October 11th. So this was the day before the judge called all the attorneys to a special hearing on the 19th. So they already knew, there was already discussion behind the scenes for Richard Allen to sign this letter on the 11th. Then we know that prior to the 12th, when she emailed them calling this meeting or this hearing, that things were afoot, that bad things were afoot. So this has been going on since least October 11th, obviously before that, because, you know, his Andrew Baldwin and Brad Rosie would have had to meet with Richard and talk it through. So please accept this letter of confirmation that I have communicated with my attorney, Bradley A. Rosie, in regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated to me that the prosecutor has requested that my attorneys be disqualified. So they knew, they all knew by October 11th that this was going down. So they knew that the judge wanted to disqualify them. So what was this meeting in chambers on the 19th? Why was it all hush hush? Why were we not aware of this? Why? Okay. So the prosecutor, so not the judge, the prosecutor has requested that my attorneys be disqualified. So the prosecutor, Slick Nick McClelland, had told Judge Gull that he wanted Baldwin and Rosie disqualified. And she said, oh, okay, Nick, my best pal. Okay, I'll do that. So she arranged for cameras to be in court on the 19th, the one and only time, so that she could publicly name and shame Baldwin and Rosie. In effect, force them to withdraw. How dirty is that? No record of this anywhere. No record that this was going down before the 11th of October. And that Slick Nick was the one that wanted this. This wasn't the judge's decision. This was Slick Nick's. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other. I believe they are acting in a manner that is in my best interest. I appreciate your time and consideration in this matter. Respectfully submitted, Richard Allen. Attorneys Rosie and Baldwin also immediately informed the prosecutor and trial court of this theft. The trial court set a hearing for 2 p.m. on October 19th to discuss these recent developments. Despite Allen's express instructions to the contrary, and remember, Sixth Amendment, on October 12th, the trial court ordered attorneys Rosie and Baldwin to cease work on Mr. Allen's case. So the day after this letter was dated, they were told to stop work. When you start piecing all these little things together, as these three attorneys have done, it starts to look more and more dodgy. I don't know. Okay. All right. Scheduled an in chambers meeting for 12:30 before the hearing. This 12:30 meeting is not noticed anywhere on the record. Now, apparently, the court reporter was there. We know that Brad Rosie has requested the transcript of that meeting, but it's not recorded anywhere. And Richard Allen was not present at that meeting where the judge was going to disqualify the attorneys. Shouldn't the defendant be at that meeting? Shouldn't that be held to, in sight, on hearing of the defendant? He was in the courtroom, in the courthouse. We know he was transported there. Why this shady meeting beforehand? And why did Judge Gull come out at 2 p.m. or at 2:30 or whenever it was, because it was really late? Why did she come out and say the attorneys have withdrawn when we know now that on October 11th that Slick Nick wanted the attorneys disqualified? Why did she come out saying, oh, there's been this unexpected development? She lied on camera to the entire world. She lied. She lied. This is a huge deal. I cannot stress enough that these dry court documents are crucial to this case. Everything that's happened since September 18th and the release of the memorandum is crucial to this case. Okay. Prior to this meeting, Attorney Baldwin filed a memorandum explaining the circumstances regarding the photographs and the fact that not only was Attorney Baldwin snookered and abused and betrayed by the theft, but more important, nothing has been disclosed that won't be disclosed at trial or hearings. Attorney Rosie similarly provided the trial court with a letter outlining what happened and enclosed the above letter from Richard Allen, stating he still wanted attorneys Rosie and Baldwin as his attorneys. During the October 19th in Chambers meeting, at which Allen was not present, even though he was in the courthouse and his presence had been requested, he wasn't even at the hearing that wasn't. He wasn't even there. Why? Because the judge had made the transport take him back to Westville. Richard Allen saw none of this day. Richard Allen, the defendant, saw less of this day than the rest of us did. How crazy is that? Every piece of that day was done behind Richard Allen's back. Even if you believe that Richard Allen is as guilty as sin for the murders of Abby and Libby, you have to be concerned at that. Surely you have to be concerned at that. Because everybody accused of any crime in any civilized society is innocent till proven guilty in a court of law. And if that court is not playing by the rules, that's a problem. That could be you next. It could be your son or daughter next. It could be your mother or father next. It could be any one of us that lives in what we believe is a civilized society. There are certain places in the world where there's complete lawlessness, where there's total corruption. And the more I think about this case, it's like reading a horror story. That this can happen in 2023 in the United States. That is crazy to me. That is crazy to me. It could, but it's not the US that's the problem, right? It's not the US that's the problem, right? If this was happening in my country, I would maybe feel that I could do more. In actuality, I couldn't. Because once a system becomes corrupt or a court becomes corrupt, there's nothing that any one of us common people can do. And this is why these attorneys who are practicing law in Indiana have been so brave in doing this. And it's why Brad Rosie and Andrew Baldwin have my complete respect for standing their ground. Because us common folk, even if you're a resident in Indiana, there's nothing you can do. Yes, you can sign a petition to have Francis Gull removed. You can do that. You can do the things. But really, the things that get noticed, then it's these people, these attorneys who are practicing in Indiana. They need to stand together because it could happen to them. It could happen to their client. It could happen in the court that they are going to be in the next trial at. And that is scary. It's scary for everybody. It's got to really concern you, even if you believe Richard Allen is guilty. The fact that this is happening to Richard Allen, he's just the latest example in a much larger problem. And if you don't know what I mean by that, go and watch my live stream from earlier today, The Good Old Boys of Delphi. It'll open your eyes. During the October 19th, 2023 in Chambers meeting at which Allen was not present, even though he was in the courthouse and his presence had been requested, the trial court read a prepared statement to attorneys Rosie and Baldwin accusing them of gross negligence in their capacity as Allen's counsel. These purported acts of gross negligence included efforts by the defence to level the playing field with a press release after the prosecution filed multiple releases. And I played a 6.5 minute clip from Andrew Baldwin, played this afternoon, talking to the media. Did he say anything that was inflammatory? No. Did he say what was in his mind, being just 5 or 6 days into the case? Yes. Did he say that he believed his client was innocent? Yes. But don't all defense attorneys say that? Yeah. And that's why at the time, that was November 2022, when Baldwin and Rosie were appointed, I took it with a grain of salt. But I'm looking at those kind of things now with completely different eyes. Because we didn't know then. We didn't know then just how bad this was going to become. But they did not say anything that was inflammatory. They didn't say anything that a defense counsel shouldn't say to the public. But it was after that they dared to speak to the press that the gag order was affected. Filing motions to protect Allen's basic human rights. Motions that the trial court either granted or that remain pending. Filing the Franks memorandum that the trial court believed contained improper statements. Filing a tort claim, so a civil claim, notice to preserve Allen's right to seek redress from conditions and treatment related to his incarceration. So all of these things are what Francis Gull believes is gross negligence. A third party's unauthorised photographing of crime scene evidence, which neither attorney acknowledged nor participated in. So that's pretty standard. A defence attorney might speak to the media, not about evidence, but about being appointed their counsel. We see this in billions of cases. Filing motions to protect Richard Allen's basic rights. Trying to get him moved from Westville several times. Filing the Franks memorandum that the trial court believed contained improper statements. Listen, a trial court, i.e. a judge, cannot make comments on any court filing that's just their opinion. What does she mean by improper statements? What's improper about it? What's improper? Filing a tort claim notice because it didn't breach the gag order. Filing a civil claim to preserve Richard's rights to seek redress from conditions and treatment related to his incarceration because the court is not doing anything about the conditions in which he's living in. And then we know all about the crime scene photos. After reading from this prepared statement, the trial court then informed Attorney Rosie and Baldwin they had two options. They voluntarily withdraw their appearances immediately, or the trial court would read the prepared statement into the record and then disqualify them in open court in front of the world's media. That she got there on purpose. There's a hearing tomorrow. Is the media welcome? No. And you know why? Well, you'll know why. If you've been taking notice, if you've been watching my lives, you'll know why. You'll know why. It's because apparently, you know, the media took video of the court before the hearing. So the media's there in court and they filmed some of the the to and fro of things going on in the court before the judge came into the court. So if she only wanted filming on record, she should have said so. But no. Media, when media's in court, they're always filming what's going on before, people coming in, people coming out, right? It was recently addressed at Idaho that the judge said, Judge John Judge said that he wants cameras in his court. He wants cameras in his court, but he only wants them to film what's on record, and that's fair enough. But he's made that clear. She didn't. Gull didn't. So how were they to know? Not to film people coming in and going out. But that's the reason she's given why cameras are not welcome in court tomorrow. That's just an excuse. That's nonsense. She never wanted cameras in the court. She only invited cameras in the court for the 19th hearing because she knew she was going to name and shame Baldwin and Rosie in front of the world's media. That's why she wanted them there, and I'll die on that hill. After speaking with Alan, attorneys Baldwin and Rosie returned to chambers and articulated that they believed the trial court had engaged in an unconstitutional ambush of defence counsel without due process. They informed the trial court that any withdrawal would be involuntary and under duress because the trial court had made clear that if they did not agree to withdraw, the court would disqualify them in open court. Attorneys Baldwin and Rosie believe this placed them in an impossible ethical bind. If they did not withdraw in chambers, the trial court would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence. They've done so much above and beyond what would be expected, and that's the thanks they get. They're doing their jobs. They're doing their jobs. And they're doing their jobs well. And this is what they get for it. Casting both counsel and the merits of their client's defence in a negative light. They believe such a public statement from the trial court risked tainting the jury pool, harming their client's defence, undermining their professional relationship with their client, and possibly creating an actual conflict for their continued representation. Faced with this dilemma, Attorney Rosie informed the trial court that he would file papers regarding his withdrawal at a later date, and Attorney Baldwin orally made a motion to withdraw. She does need removing, Stephen. You're absolutely right. And this is why this is so important, that these attorneys have done this. That the Supreme Court of Idaho, no, Indiana, did it again. The Supreme Court of Indiana needs to, well, the ball's in their court now. It's going to be heard at the Supreme Court. After the events of October 19th, Alan instructed Attorney Rosie to file a notice on October 25th indicating that Alan did not want him to withdraw as counsel. This notice informed the trial court that there was no circumstances under Rule 1.6 of the Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rosie's representation of defendant Alan, and that everything cited by that trial court as constituting alleged gross negligence was either not attributable to Attorney Rosie or was the product of ethical lawyering in the best interests of the client's defence and mental and physical well-being. Again, Rosie had nothing to do with the leaking of the crime scene photos. It was not his office. He works at a different firm. Was not his office. This notice also stated that Alan was asserting his constitutional right to counsel of his choice and wanted Attorney Rosie to move forward with the representation of defendant Alan until a final deposition of this matter. The notice further pointed out that unless Attorney Rosie was allowed to continue as counsel of record, the jury trial set to commence on January 8th, 2024, which was already a full 15 months after Alan's arrest, would have to be continued, which would unreasonably prejudice Alan. Alan also instructed Attorney Rosie to file a motion seeking the trial court's recusal and a motion asking for a continuance of the October 31st hearing because of the many unresolved pending motions in that case. So that was that document that Rosie wrote, wanting the judge to disqualify herself. What's the reasoning for the judge to put him in prison? Oh, for his own safekeeping. Because apparently Carroll County Court, Carroll County Jail could not keep him safe. And apparently no other county jail could possibly keep him safe. Although Cass County has said that they can keep him safe, they would volunteer to have him. They have the capacity, they can keep him safe. But no, consistently, that has been refused. Consistently refused. Notwithstanding these filings, on October 27th, the trial court issued the following order declaring that Attorney Rosie is no longer counsel of record and ordering the clerk to remove all of Alan's filings from both the system and the electronic case file. So you'll know that from Rosie's documentation. All right, so that's more legal stuff. Okay, we'll read this. Asserting Sixth Amendment rights, Alan has only consented and authorised attorneys Rosie and Baldwin to represent him in the trial court below, and only they are authorised to make filings on his behalf. As noted above, however, the trial court refuses to accept any filings made by these attorneys and orders the clerk to remove anything they file. Thank you, Jane, for the £10. Thank you, thank you. Oh, it's a super chat, so I can heart it. I wish they let me heart super stickers as well, but the function isn't there at the moment. Accordingly, there is an impossibility of performance on the condition precedent. Alan believes this is analogous to the condition precedent of the appellate court, so the appeal court. So if Richard, you see, this is another thing, right? If Richard Allen ever needed to appeal a decision of the court, the documents that he would want to appeal about don't exist. They don't exist in the court system. So that's a massive problem for any future appeal. Is that the reason why the judge is doing this? So Richard Allen would have a huge problem in appealing anything that her court decided. I think so. I think that's one reason. The facts and current posture of this case rise to this level of extraordinary circumstances, and Alan therefore requests that this court similarly excuse the condition precedent otherwise required for original action. So this is just legal stuff. The trial rules mandate that the trial court clerk shall maintain a sequential record of the judicial events of such proceedings, and that the system must reflect all trial court events. That includes any and all filings. So the fact that the judge is just playing willy-nilly with these filings is a massive problem. And they may well get her here. They may well get her here on this nonsense way that she's been behaving. They may get her on this. In addition, the court has unequivocally mandated that Indiana court records are to be open and accessible by the public, noting that there are strong societal reasons for allowing public access. So we've talked about all of that. So again, we've got more legal stuff. So these are the grounds for making records confidential if they need to, which are standard. Some documents are confidential. So anything that's got, names or events that are evidentiary, that if they got out into the public, they would create an issue. There's some reasons why documents are recorded as confidential. So, for example, in the memorandum, many of the exhibits were confidential. Like the exhibits haven't been released anywhere, but there were some that were recorded as confidential. So things like crime scene photos, things like that. Quite rightly, they shouldn't be publicly available. Okay, so again, more legal stuff about public access. The trial court continues to violate these absolute duties by improperly removing documents from the system and excluding public access to documents filed in this case. The trial court failed to perform a clear, absolute, and imperative duty imposed by the trial rules and access to court records when it removed and excluded the Franks memorandum and also ordered the clerk to remove all of Allen's most recent filings. This is simply not allowed under either set of rules. The trial court's belief that these filings are either improper or unauthorized does not justify the removal or exclusion of the court records from the system altogether. They could well get her on this, and I really hope they do. I really hope they do. Because if she's prepared to do this, then there's no way that she's going to be an impartial judge. She's not. And I think while they're at it, the Supreme Court of Indiana needs to go and have a look at what else she's been getting up to in other cases that aren't high profile, that don't have defense attorneys as studious and as prepared to defend their client. Like, what if Richard Allen had a couple of public defenders who were a bit lazy, who just wanted to get this over and done with, and, they just wanted a nice, cushy life, and they didn't really care about the client at all? We wouldn't know any of this. None of it. And that's why it concerns me so deeply about who the two attorneys, the two new attorneys are. What's his name? Scremin and Liberato. Liberato particularly. Not just because he has bad Google reviews, as I talked about the other day, but because he's the chief public defender in Allen County. They're even friends on Facebook. I mean, come on. Who? Right, what attorney puts as a judge on the Facebook? Go on Reddit and you'll find out that Liberato has a lot of judges on his Facebook. There's a little kiss ass. This court needs look no further than how Indiana's appellant court handle these situations. If an appellant court concludes a filing is improper or unauthorized, it issues an order or opinion stating the same and does not consider the filing, but it does not remove it or exclude that filing. Okay, some more legal stuff. The bottom line is that the trial court may enter whatever order it deems appropriate to address any court records the court believes to be improper or unauthorized, and it may inform the parties and public that it will not review or consider such filings. What the trial rules and access to court records do not allow is for those filings to be removed or excluded from public access. Okay. And they go on to say, so they've chosen this. They've been very clever. They've chosen something that they can absolutely evidence. So it may seem small in the general scheme of things, but these are the things that they can evidence without it being an opinion, without it being a bias, but just laying out the law and saying, this is how Francis Gull's court has acted, and this is why. And it brings all the issues, you know, the real issues, into the Supreme Court in a way that would not have been possible had they not used all of these procedural, you know, well, look at this, the public doesn't have access to this and it doesn't have access to that. It's brought in all of the issues together. So it's nice. It's nicely done. I like it. Nicely done. So this is just a conclusion. Let's read this conclusion. If there was ever a time when the openness mandated by the trial rules and the access to court record rules was critical, it's in the present case, one of the most high-profile cases this state has ever seen. For many Hoosiers, this is the first time they have followed the workings of courts in this state. Yet the trial rules and access to court record rules have been repeatedly violated, leaving the public and media in the dark. A writ of memorandus prohibition is appropriate to ensure that going forward, this court's mandate regarding public access are followed without exception. And then those are the names again. Okay, and these are the people that it's gone to. So these are the people who've got this record now. It's in their inbox. It's in their inbox. Let's have a look. So Francis Gull, Robert Scremin, William Liberato, Slick Nick, and Theodore Rakita, who's Slick Nick's deputy. So yeah. So now we were. Who's Gull, the judge? Francis Gull is the judge. Okay. That's it. So now we wait. There has been something from the Supreme Court, according to Reddit. Okay, let's find it here. Here we go. So there is a response to this. In the Indiana Supreme Court, Richard Allen, by counsel, has filed a verified petition of writ, seeking relief under the rules governing original actions. Any briefs opposing issuance of the writ or any supplemental records must be filed directly with the clerk of the Supreme Court on or before Thursday, November 9th. So date for your diary, Thursday, November 9th. So if Slick Nick wants to respond, or any of the other people that this has gone to want to respond, including Judge Francis Gull, then that's the time that they need to respond by. Any supplemental record must be submitted in the same format required for the record under original action, blah, 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 blah. Once briefing is complete, the court will take the matter under advisement. There you go. So that's the response from Loretta H. Rush, Chief Justice of Indiana, the Chief Judge of Indiana, has this document in her inbox. So presumably that is just a standard response, a standard reply. But there you go. The ball is not just in Francis Gull's court. The ball is now with the Supreme Court of Indiana. There you go. So that is good news. That's good news. Oh yeah, I really can't. I really don't think the trial's going ahead in January. I think even June is going to be pushing it. I mean, look, if this Supreme Court thing is done pretty quickly, then no, as I was going to say, best case scenario, the Supreme Court just says, you know, Francis, what you playing at? I'm going to disqualify you, like Loretta says to Francis. I'm going to disqualify you if you don't let Richard Allen have his old attorneys back. That's best case scenario. In which case, there probably would still be a delay to the trial, but it wouldn't be one that would be months and months and months away. It would be, you know, look, if Francis Gull is removed, then that's best case scenario. If Francis Gull's removed and the Supreme Court don't see an issue with Baldwin and Rosie continuing, then with a new judge, because you know, it's not like a judge has to learn the case, is it? Thank you so much. Thank you, Dulcie, for the 20 Australian dollars. Thank you so much. I can heart that one as well. Thank you. Apparently, that's your third super chat on a live stream. I love the way that YouTube is telling me now how many super chats people do. I don't know whether I need to know that or not, but there you go. So Francis Gull gets removed and Rosie and Baldwin get reinstated. I can see that the trial going ahead with a small delay. But with a new judge, the big issue is the Franks hearing that we've kind of all forgotten. That there is thousands of pages and thousands of hours of video. Maybe not thousands of hours of video, but there's 136 page memorandum, but there's a considerable number of exhibits because Rosie and Baldwin have come with receipts. So the issue of the Franks hearing would be probably one of the first things that a new judge would have to decide on. And if that judge realizes that under Franks versus whoever, in whatever year, the search warrants of Richard Allen's home were illegal, there is no case whatsoever, and the case will be dismissed. So things could get very, very, very interesting in the relatively near future. Yeah, that's true. Yeah. If it's a judge that's got lots of cases and stuff like that, then yeah, it'll have to fit into the judge's schedule. So yeah, there is that. Well, yes, on paper he was. From the 19th to a few days ago when Libretto and Scremin were appointed, yes, he was in prison, unrepresented, according to Frances Gull, because she claimed that Rosie and Baldwin were withdrawn. They withdrew themselves. So yeah, for that period of time, Richard Allen was unrepresented. Yes. Thank you, Laura. Thank you so much for the $10. Oh, okay. Rakita is not. He's the Attorney General for the entire state of Indiana. Oh, thank you. I just assumed, because I can't remember the deputy's name. It was said on Slick Nick's thing. Right, okay. Thank you. That's even better that the Attorney General of Indiana has got it. So it's not just Slick Nick's deputy that's got it. It's the Attorney General of Indiana. That's even better. Thank you for the $10 and the clarification. Thank you so much. I don't know. And that will depend on the Supreme Court. I don't know. There will be an investigation of her. They'll remove her and then they'll investigate to find out. And hopefully that investigation is a very thorough one. Yeah. Yeah, it is. Sixth Amendment. Can a case be moved to a different county? Yeah. Yeah, it can be moved to a different county. It was decided that Richard Allen's case would stay in Carroll County, but that the jury would be appointed from a different county. The name of the county escapes me, but that was the decision made in this case. But it's absolutely the case that a trial can be taken completely outside of the county in which the crime occurred if there's a reason to do so. And it being high profile is one of the reasons why a case might be taken out of the particular county. Same in this country. If anybody followed the case of Olivia Pratt-Corbell, who was a little 9-year-old girl who was shot and killed in Liverpool last year. They realised that Thomas Cashman, the accused, wouldn't get a fair trial if they held the case in any court in Liverpool or indeed in Merseyside. They took it out of the county and gave it to Manchester. So his trial was held in Manchester because they realised that there was no way in the world he would be given a fair trial. And he's an absolute rot bag and clearly guilty. And yeah, but it was absolutely right that they did that. So yeah, it's not unusual at all. And it actually happens a lot in this country. But yeah, I think it would be a good idea to move it out of Carroll County. Tina, member for 12 months. Thank you. A whole year. Thank you so much. Nick McClelland is the prosecutor. And then he's got a deputy who I assumed was that Theo dude. So it's Nick McClelland, Slick Nick, who is the prosecutor. Did I? Are you sure? Have I missed a donation? I'm sorry if I have. So Laura donated. So that was the Attorney General comment. Dulcie, did I? Yeah, I hearted your comment. So yeah, those are the only ones that I can see. But if I did miss another one, I am really sorry. Hold on a minute. My chat's frozen now. Oh, there we go. That's better. Oh, no, I haven't. Oh, good. All right. Okay. Let's see if there's any more questions that I can answer. Oh, hopefully she gets disbarred. That would be great. That would be great. But let's not think too far ahead. Let's hope she deserves it. But we'll see. It does. It does. It does. It does look sleazy. Absolutely, everybody should be held accountable. Doesn't matter what job they do. I mean, you know, there's rotten apples in every profession, isn't there? You know, this afternoon in the live, we were talking about corruption and, you know, law enforcement making just riding roughshod over people's lives. The case of Jesse Snyder we talked about. But there's some really, really good police officers. And you can't tar every law enforcement official with the same brush. But when there is rotten apples in the barrel, it's really bad. It destroys people's lives. And it's exactly the same with judges. There's some really good, fair judges, many of them. But there are some rotten apples, and then they need to be removed. And any profession, It's the same. Just because somebody's a judge doesn't mean that they deserve their position. Where's Kyle? Is it his girlfriend's tonight? He rang me earlier with a Microsoft Excel question. I was his tech support before I went live. And then he's working tomorrow. Yeah, Jen, I did acknowledge yours. Yeah, I did. There is. Everywhere you turn, there's rotten apples. But usually they get found out eventually. Yeah, Judge Newman. Absolutely, Sharon. Judge Newman in the Murdoch case. Brilliant judge. Judge Werner as well was okay from Letitia Stokes' trial. He was very fair. Very quietly spoken, but very fair, I thought. But Judge Newman's brilliant. Loved his expressions, just brilliant. And very on the ball, like just didn't take any messing from anybody. Just really good. Bobby, thank you for the $20. Thank you so much. Thank you. Thank you. Thank you. Thank you. Can I heart that one? Oh, I can heart that one. Yay. That's your first super chat on a live stream. Oh dear. YouTube. They're not. Nobody's infallible. Nobody. And the thing is, everybody makes mistakes, even judges. But when there are mistakes like this that are clearly just obvious bias, that's a problem. Massive problem. Judge Dowrow. I don't know that judge. Who's that judge? What's he the judge of? Oh, that's a shame. And that's why in this court documentation that has come out today, I think they've played it really well. That they've not tried to name and shame the judge for every single thing. They've used what they can evidence. There's no opinion in there. It's just all about what they can evidence and what the law says. And for that reason, I think the Supreme Court of Indiana will have to investigate. There's no opinion, it's just laid out very nicely. You don't know how to send a super chat. You go to the bottom of your screen where you put your chat in, and then you see a little $sign. If you hover over the $sign, it says show your support for MichelleAfterDark, and then click on that, and then it gives you an option to send a super chat if you want to. So it gives you, let me see what options it gives you. You can either do super sticker, super chat, membership, but you're already a member, so that's not relevant. Or membership gifting. They're all there. Oh, Daryl Brooks. Oh, I didn't follow that case. I didn't follow Daryl Brooks. So that's why I didn't recognize the name. Yeah, that's Judge Werner. Yeah, Letitia Stout. Yeah, he was very fair. I could he was very quiet. I had to really listen when he was talking, but Very fair. Thank you for the 10 Australian dollars. Thank you so much. I can heart that one as well. Starkey Rottweilers. Thank you, the Big Island. First super chat under your current handle. I wonder whether YouTube will recognize that or not. But thank you so much for the $9.99. I don't know why sometimes it takes like a cent off people or a penny off people. It does that sometimes. When I super chat people, it always takes a penny off mine. Like I put like $5 or well, £5 or £10 or whatever. It always takes a penny off. I don't know why it does that. Yeah, he was good, wasn't he? Yeah, I just never followed the case. I was saying, was it today or whenever, that there's some... Oh, it was on my members live yesterday. That there's a lot of trials going on at the moment, and I'm not watching any of them. But there will come a time when it's a slow news week in true crime, and I'll just sit there and binge watch an entire trial. I did that for what's his name, the fat one, Anthony Tote. I just literally watched his entire trial all at like one go. I just like one day after another, after another, after another. It was only a small trial. It was only like 4 or 5 days. So I got through it in like a couple of days. So I do that. I wait till I want something to watch, and then I just pop onto Court TV and think, oh, let me see what trials I can watch. So yeah, there's quite a few that but yeah, the Darrell Brooks case, I've just never followed it. It's just one of them. But I guess there's like what was it, Johnny Depp, Amber Heard. I had absolutely no interest in that whatsoever, and I still don't, and I'll never watch that. And there's no particular reason. It's just that everybody was talking about it, but I don't follow celebrities. I don't follow it. And I'm just not interested. I really need to check out Darrell Brooks. Didn't he poison his wife? I don't know who you're talking about. What, Darrell Brooks? I don't know. I don't know the case. But Anthony Tote, he's an absolute rotter. Killed his wife, kids and dog. Killed them all. Oh, really? Represented himself. Tried to turn it into a circus. Oh, I think I vaguely remember. It wasn't that long ago, was it? Oh, I'm going to have to go and watch the trial now. I'm going to have to. And I think another thing with Johnny Depp and Amber Heard, that it was a civil case, and not that civil cases are any less important than criminal cases, but that was a kind of another kind of tick box. You know, I prefer criminal cases, so it was another tick box that it didn't hit. So it was like, oh, it's celebrities and it's civil, and nah. So I don't think I've ever even mentioned it. I just didn't watch it, didn't follow it, didn't watch any of the live streams that people were doing about it, and everybody was talking about it. It was all over everywhere, and I just purposefully avoided it. He's so annoying. Oh, I love it then. Because you know when you have this villain that you're just like shouting at the screen. So I'm definitely going to have to next time I've got like a few days to spare, I'll watch Darrell Brooks. Oh, it is. Oh, Anthony Todd, absolutely horrendous. Like, it's interesting that everybody remembers Chris Watts for what Chris Watts did. And Anthony Todd was just as bad, in every which way as bad as Chris Watts. And nobody knows Anthony Todd. But at least Chris Watts spared the dog. Chris Watts didn't kill Dieter, the dachshund. Whereas Anthony Todd even murdered Breezy, the little spaniel. I don't know what breed Breezy was. She looked like a little spaniel type, maybe a crossbreed, but yeah, even murdered Breezy. Why? Oh, Dieter knew, yeah, absolutely. Dieter knew, Holly. If only dogs could talk. You know, there's so many cases where the dog's a witness and the dog's the only witness. And they can't say, sadly. Oh, wasn't he? He's one of them that you just want to reach through the screen, grab him by the jaw and shake him as hard as you can. Really annoying. He's a really annoying guy. Like trying to like put on this like air of like, oh, I'm so sad. Like looking at the jury and oh no, go away. Even worse actor than Murdoch. If you thought Murdoch's snot fest was bad, then Anthony Todd was even worse. Yeah, the Akita and the OJ case. Yeah, the dog knew. There's loads of them where dogs are the only witness. We had one recently in the UK. Like, wasn't a criminal case of, as we found out, but the case of Nicola Bulley. The only witness to what happened was the dog. It was the dog Willow, Springer Spaniel. Anyway, guys, I'm going to go. It's almost another 2-hour live. All right, let's see what tomorrow brings. So I don't know whether we can expect a response from Frances Gull herself or not. So, oh no. Your cat was the only witness who broke and robbed your house. Oh. Oh. All right, guys, I'm going to go. Thank you so much. You've been dead generous to me tonight. Thank you for the donations. Thanks, as always, to the mods who, you know, worked putting the links in and stuff. And yeah, enjoy the rest of your evening. It's now 10 past midnight for me in the UK, so I'm off to bed. So enjoy the rest of your day, and I shall speak to you very soon. Bye, guys.